Hello everyone. Welcome back to my channel Study with Neha Mawa. So after a very long time I am back with the another video, and in this video I am going to start the contract, the law of contract or the Indian Contract Act. So without wasting time, let's get started. So in this, firstly we have the introduction to the law of contract. Firstly, as we know that a single individual do a lot of contract into their day-to-day basis. In our daily life, we do a lot of contract. Like contract is a kind of the sale and purchase. So we do a lot of contract in our day-to-day life. For example, when we are buying vegetables, when we are buying fruits, or when we are buying clothes, or when we are doing some another act, we are just entering into the contract, right? So section 2 subclause H of the Indian Contract Act 1872 defines the term contract as, if we see the definition, an agreement which is enforceable by the law is a contract. Contract is the agreement between the two parties that is enforceable by the law and that is valid and that needs to be executed between the two parties. As I gave you the example, for example, I am going to the market and I am buying the vegetables. When I am buying the vegetables, there's a contract or an agreement between me and the vegetable seller that the vegetable seller will give me the vegetables, and in reverse to that I will pay the uh, money. I will give the money or the consideration for that particular vegetable. So by the definition we can easily say that agreement between two or more than two parties to do or abstain from doing anything. So contract is basically the agreement, and that agreement should be between the two parties in order to do a certain kind of act or the work. Two important things for the formation of the contract. First is the agreement plus the enforceability. Now when you are entering into the agreement or whenever you are making the contract, that should be legal. If you are entering into a contract or agreement with the wrong intention, or with the intention or with the act that is strictly enforceable by law, that is strictly forbidden by law to do, then it will become an offense. So first we have the illustration. There is an agreement between X and Y that X will construct a house for Y and Y will pay rupees 10 lakh to X. Agreement between A and B is a contract because it is enforceable by law and there is the proper and the pure intention between the parties. But if the intention of the party becomes offensive or is not legal, is not pure, then it leads to a certain kind of definition or certain kind of scene that will not be acceptable by the society as well. Then we have the agreement under the Indian Contract Act. Firstly, as I told you, firstly there's a contract. Contract is equal to agreement plus enforceability. Means, as I told you in my earlier slide, that there was a formula of the contract, that is the agreement plus enforceability, or agreement plus enforceable. Means, in order to constitute a contract, firstly there should be agreement between the parties and that agreement should be properly enforceable. Means the agreement should be legal enough to enforce it. Then when we are talking about the agreement here, agreement comes under section 2 subclause E of the act, defines the term agreement as every promise and every set of promise forming the consideration for each other is an agreement. For example, here you can see agreement is equal to promise plus consideration. For example, I went to a market, I went to vegetable seller, and vegetable seller promised me to give me the vegetables, and in reverse to that I promise that I will give the consideration. There's a promise and there's a consideration side by side, it becomes the agreement. So agreement has its own definition, has its own formula, that is promise plus consideration. Then we have important case here, Balfour versus Balfour case. It is very, very, very important in whole Indian Contract Act, in which it talks. So in Balfour versus Balfour case, Mr. and Mrs. Balfour, they used to live together as a married couple in Sri Lanka. One day they went for a vacation to England. So during this time, Mrs. Balfour developed arthritis. Doctor advised Mrs. Balfour to stay in England because the weather of the England was good for her, but not to visit to the Sri Lanka. But due to, as we know that Mr. Balfour has all its work in Sri Lanka, so he used to go Sri Lanka, and he promised his wife that he will send him a sum of money every month, but he failed to do so. It was held that when the Mr. Balfour promised his wife to pay a monthly sum of a certain amount and he did not pay that, so it does not amount to a contract, because there is no intention to create a legal relationship on the parties of either of the parties, which says that when there is a relation between the husband and the wife, so there the contract does not arise. Here, Mr. and Mrs. Balfour, they both have a relation of husband and wife. So if sometimes Mr. Balfour becomes unable to pay the monthly maintenance to his wives, so it does not mean that the wife will sue his husband. No. So here it was held in this case that there was no contract between Mr. and Mrs. Balfour, because there's no intention of the parties to enter into a legal relationship, because they have already been in existence in the marital relationship with each other. They have a marital relation with each other, so that does not constitute that they will form a contract and they will enter into a legal relationship. So we can't make Mr. Balfour liable for that particular act, because it depends upon the discretion of the Balfour. So here they have a husband and wife relation, marital relations, so they can't enter into a legal relationship. So as they said that Mr. Balfour promised to pay a monthly sum of this amount, did not amount to a contract, as there was no intention to create a legal relationship on the part of either of the parties. Generally, contract occurs, or generally contract is made in that circumstances where the parties does not know each other. When the parties are strange to each other, then only the contract or the agreement is being made. But when the two people, they are in relation with each other, and they are they mean to each other, so there does not point arises that there will be a contract, so no question of the contract will arise there. Then we have classifications of agreement. We have valid agreements, we have voidable agreement, we have void agreement, illegal and unenforceable. Valid agreement are those agreements that are enforceable by law, and these are the genuine agreements. Voidable agreements are those agreement which is enforceable by law at the option of one of the parties. Okay, then void agreement means this agreement is not enforceable by law at all, because they are void from the very beginning when it is made. Illegal agreement, these agreements are also not enforceable by law, because they are against the law. Unenforceable agreement means that are those agreements which cannot be enforced in the court of law on account of some technical defect, like want of proper or written form or stamp. If the stamp is not there, written form is not there, or some error omissions are there, then it becomes the unenforceable agreements. Then we have the promise under Indian Contract Act. See, according to Section 2, Subclause B of the Act, when the offer is accepted, then it becomes a promise. For example, when a person to whom the offer is made signifies his assent, then we can say that the offer is accepted, right? So for example, A made a offer to B. After 2 3 days, B signifies his assent, then send back to the A. Here, when the offer is accepted, it becomes a promise. Then genuinely it becomes a promise. So there are mainly four kind of promise. Okay, promise means, for example, as I told you, the promise means that uh, when you are offering something to a person, and then when other person accepts that, or is willing to enter into a relationship, or when the person is willing to do a certain kind of act, it becomes a promise. Then there are four type of promise: express promise, implied, reciprocal, and alternative. Express promise means when the promise of any offer or acceptance is made in words, then the promise is said to be express. When it is expressed by the way of words, or written, or by writing, or by email, or by anything. Implied promise means when the promise of any offer or accepted is made otherwise than in word, then promise is said to be implied. Implied promise means, or implied act means, when you, for example, when you enter into a restaurant, right? You ordered the food and you ate the food, you finished the food. Now it is implied that you have to pay the bill. So implied means when you know what is to be done, and no other person will mention you, or when the other person will not make you to understand that you have to do a particular act, it becomes the implied promise. Implied promise means when you yourself knows what to do next, it becomes the implied promise. Reciprocal promise means promise which form the consideration for each other are called the reciprocal promise. An alternate promise means an alternate promise is one which offer the choice of one of two things. Alternate means when you have different options, when you have different choice, and you can choose one of those alternative choices. So, guys, this was all about the contract. In this video, I just talked about the introductory part of the contract. What is contract? How contract is made? How agreement is made? And how the offer and acceptance is being done. So, this was just the introductory video of the Indian Contract Act, and in the next video, next slides, I will start with the consideration part, where I will tell you about what is consideration and all. So for that, please subscribe to my channel, please like my video and share with your friends. Thank you for watching my videos, and I will come up with more videos like this. Thank you.